A mother sends her child into the Colorado juvenile justice system expecting rehabilitation. Instead, she discovers conditions so disturbing that she joins other mothers in a civil rights lawsuit against the state. What these families uncovered inside these facilities has sparked outrage and could reshape how America treats its youngest offenders. Welcome to Court Decoded. Today we cover the explosive civil rights lawsuit filed by Colorado mothers against the state's juvenile detention system, a case exposing allegations that could change juvenile justice forever. The American juvenile justice system was founded on a noble principle that young offenders deserve a chance at rehabilitation, not punishment. Colorado, like most states, operates detention facilities designed to house youth awaiting trial or serving sentences for various offenses. These facilities are legally obligated to provide education, mental health services, and safe conditions. But according to a growing chorus of mothers whose children have passed through these centers, the reality falls devastatingly short of that promise. These mothers describe a system where children emerge more traumatized than when they entered, where basic needs go unmet, where the constitutional rights guaranteed to every American, including the youngest, are allegedly violated behind locked doors and concrete walls. The mothers at the center of this lawsuit share heartbreaking testimonies. They describe phone calls with their children where desperation bleeds through every word. Children reporting inadequate mental health care despite entering the system with documented psychological needs. Allegations of prolonged isolation, a practice that child development experts warn can cause lasting psychological damage to developing brains. One mother recounts how her son's condition deteriorated dramatically during his detention, emerging with new traumas layered upon old ones. Another describes the helplessness of watching her daughter spiral while facility staff allegedly failed to provide promised interventions. These are not abstract policy complaints. They are the documented experiences of families who trusted the system to help their children, only to watch them suffer. The lawsuit filed against Colorado authorities centers on alleged violations of fundamental civil rights. At its core are claims invoking the Eighth Amendment, the constitutional prohibition against cruel and unusual punishment. The mothers and their legal representatives argue that conditions inside these juvenile facilities cross the line from strict discipline into unconstitutional treatment. Specific allegations include inadequate medical and mental health care, excessive use of solitary confinement, failure to protect youth from harm, and denial of educational services required by law. Under established legal precedent, the government has a heightened duty of care toward those it incarcerates, a duty that increases when dealing with minors whose brains are still developing and who are particularly vulnerable to institutional harm. What exactly happens behind the walls of Colorado's juvenile detention centers? According to the lawsuit and supporting testimonies, a troubling picture emerges. Youth reportedly spend excessive hours confined to small cells with minimal human interaction. Educational programming, legally mandated for all detained minors, allegedly falls far short of requirements, leaving children to fall further behind academically during crucial developmental years. Mental health services, despite being desperately needed by a population with high rates of trauma and psychological disorders, are described as inadequate and inconsistently delivered. Staff shortages allegedly leave facilities unable to maintain safe environments, with incidents of youth-on-youth violence going inadequately addressed. The mothers paint a picture of warehousing rather than rehabilitation, a system that has abandoned its founding purpose. This lawsuit operates within a well-established legal framework for challenging detention conditions. The Eighth Amendment, as interpreted by the Supreme Court, requires that incarcerated individuals receive adequate medical care, protection from violence, and humane living conditions. For juveniles, additional protections apply. Courts have consistently recognized that children are constitutionally different from adults. Their brains are still developing, they are more susceptible to negative influences, and they have greater capacity for rehabilitation. Federal law also requires educational services for detained youth under the Individuals with Disabilities Education Act. When facilities fail to meet these standards, civil rights lawsuits become the primary mechanism for accountability. Previous cases nationwide have resulted in court-ordered reforms, consent decrees, and substantial changes to how states operate juvenile facilities. The Colorado lawsuit exposes what advocates describe as systemic failures rather than isolated incidents. Multiple families, multiple facilities, multiple years of alleged neglect suggest problems embedded in how the state operates its juvenile justice infrastructure. Critics point to chronic underfunding that leaves facilities understaffed and under-resourced. They highlight a culture that prioritizes security and control over therapeutic intervention. Oversight mechanisms that should catch problems before they escalate have allegedly failed repeatedly. The mothers argue this is not about individual bad actors, but about a system designed in ways that inevitably produce harmful outcomes. Their lawsuit seeks not just compensation for past harms, but fundamental structural reforms that would prevent future children from enduring similar experiences. Colorado state officials face difficult choices in responding to these allegations. Governments typically defend against such lawsuits by challenging the factual claims, arguing that conditions meet constitutional minimums, or asserting qualified immunity for individual defendants. The state may point to improvement efforts already underway, budget constraints limiting what is possible, and the inherent challenges of managing facilities housing troubled youth. However, when evidence of systemic problems becomes overwhelming, states sometimes choose settlement over prolonged litigation. Settlement agreements and consent decrees can mandate specific reforms while avoiding admissions of liability. Whatever path Colorado chooses, the spotlight now shining on its juvenile facilities makes continued denial of problems increasingly untenable. These Colorado mothers represent part of a growing nationwide movement challenging conditions in juvenile detention. From Louisiana to New York, from California to Florida, similar lawsuits have exposed troubling conditions and forced reforms. The movement draws strength from shifting scientific understanding of adolescent brain development, which has influenced Supreme Court decisions limiting harsh sentences for juveniles. It connects to broader criminal justice reform efforts, questioning whether incarceration achieves its stated goals. For these mothers, the fight is deeply personal. They have seen their children harmed by systems meant to help them. But their lawsuit carries implications far beyond their individual cases. A victory here would establish precedents strengthening protections for detained youth across Colorado and potentially influence how other states approach juvenile justice. This civil rights lawsuit against Colorado's juvenile detention system remains ongoing, with outcomes yet to be determined. However, the case has already achieved something significant. It has forced public attention onto conditions that typically remain hidden from view. The legal lesson here is profound. Even those society has decided must be confined retain fundamental constitutional rights. The Eighth Amendment does not stop at prison gates, and it certainly does not stop at the doors of juvenile facilities. When systems designed to rehabilitate children instead cause harm, the law provides mechanisms for accountability. These Colorado mothers have demonstrated that ordinary citizens, armed with constitutional protections and legal representation, can challenge even powerful government institutions. Their fight continues, and America watches. If you found this case fascinating, hit subscribe and the notification bell for more legal breakdowns every week. Share your thoughts on juvenile justice reform in the comments below.